I'm most pleased to welcome you to this, our first Health Law and Policy seminar of the year, and it promises to be a really good one. My name is Constance McIntosh, for those of you who I've not yet met, and I'm the new director of the Health Law Institute. So if you haven't seen me around before, you're going to see a lot more of me these days. The Institute has been running this seminar series for 14 years, which is quite a record, I think, for Dalhousie. There's one brief announcement that I'd like to make because the news just went officially public this morning, and that was the creation of the McBain Chair in Health Law and Policy. So that was a very exciting moment, both for me as a director and in terms of what the Health Law Institute is going to be able to achieve in the coming years. We're very excited to be hosting today's seminar, which, as you may have observed, is going to be taped and live streamed. Today's seminar is co-sponsored by the European Union Centre for Excellence, located here at Dalhousie. And it's also sponsored by the Canadian Centre for Ethics in Public Affairs, which we fondly know as CCEPA. Chris Stover, who is the General Manager at CCEPA, is now going to say a few words before I introduce today's speaker.
Hello everyone, as Constance mentioned, I'm with the Canadian Centre for Ethics in Public Affairs. Some of you may know of us. For those of you that don't, we're a national ethics centre that is co-founded by the Atlantic School of Theology and St. Mary's University here in Halifax. And our mandate is to provide an arena for critical thinking on all matters as they intersect with ethics. And we do this in a few ways, one of which is public programming like this. Another is supporting research, and we also provide consultation services. We present about a dozen programs a year right across the country in collaboration with other like-minded groups and organizations, government departments, businesses, and universities. We fund 2 or 3 fellowships a year, and we also support a scholar-in-residence program. We offer consultation services for organizations and businesses that are looking to shape governance or value statements. And all our current and past programs can be viewed on our website. And often, as we're doing here today, we live stream. So it's always a good idea to check the website if there are things that interest you, because you could be able to check into a live stream program that we're doing somewhere else in the country and take advantage of that. I've left some copies on the side table over here of DVDs of programs that we've produced in the past. You're welcome to take those home with you and enjoy them if they're of matters that interest you. But if you see things there that you think that you might like more of, pick up a business card, shoot an email to me, and I'd be happy to mail you any of our DVDs that we have on hand as a resource that you can use. We've also over there got some evaluation forms, and your feedback's really important to how we develop future programming. So if you could, take a few minutes at the very end of this presentation and let us know how you feel about what the program was like. We'd be hugely grateful. We're probably best known for our collaborative approach to our public programming, and so we're very pleased and grateful to be joining with the Health Law Institute here at Dalhousie and the European Centre for Excellence today to contribute to this opportunity. So thank you very much.
So, today we are very fortunate that Penney Lewis has agreed to come from England and deliver this first lecture. Her past studies include math, law, philosophy from the United States, Canada, and England. Kind of got a little bit of everything from a little bit of many places. She clerked at the Supreme Court of Canada. She was called to the bar in Ontario. And she's currently a professor of law at King's College London, where she teaches in medical law and law at the end of life. She's given evidence before parliamentary committees in the UK and Scotland on end-of-life reform. She is very widely published, including her book titled Assisted Dying and Legal Change. Please join me in welcoming Penney Lewis.
Thank you very much for that lovely introduction. I am going to talk about end-of-life decision-making and the way in which the law regulates it across Europe. And I'll give you a little bit of sort of focus towards the end on the United Kingdom and in particular recent changes in relation to assisted suicide. But we'll start with a more general overview. So if we think about what is an end-of-life decision, I'm using a rubric that's used extensively in empirical research on end-of-life decision-making across Europe. So I've broken end-of-life decisions down into abstention. More commonly, we think of this as either withdrawal or withholding of life-sustaining or life-saving treatment. Symptom alleviation with possible or probable hastening of death. Assisted suicide or physician-assisted suicide, euthanasia, which in the Netherlands and Belgium is defined as termination of life on request. So then, of course, we need some terminology for termination of life without a request, and they just call that termination of life without request. So we need to also think about who is the decision maker. So decision makers, I suppose, most obviously would be the patient. And what's quite common across North American jurisdictions, some sort of legal proxy for the patient, either someone who's been appointed by the patient prior to incompetence, or is presumed to be the legal proxy through some sort of qualifying relationship, some sort of family relationship usually, or appointed by a court. Another legal proxy for the patient, particularly common in the UK, is the doctor. And finally, some decisions are generally made by courts. So let's start with a quick look at abstention. So how is it that a decision is made to either withdraw or withhold life-sustaining or life-saving treatment? So we might have a competent patient who refuses life-sustaining treatment either contemporaneously, I don't want that blood transfusion, thank you, or in advance through some form of advance directive, advance decision. In England and Wales, these are called advance decisions to refuse treatment, or living will. We might have a legal proxy for the patient making a decision to refuse life-sustaining treatment using one of a number of different legal standards, usually falling into two categories, either substituted judgment, what would the patient have wanted, were she able to make this decision for herself, or best interest, which is the standard that's used in England and Wales. What is in this patient's best interest? Is it in her best interest to continue to receive treatment, or is it in her best interest to have that treatment withdrawn or withheld? Alternatively, we might have a doctor making a decision either on the basis of some form of futility, often clinical futility. This treatment simply isn't going to work in this patient, so there's no point attempting CPR on someone who's in the very last stages of dying of cancer. Either on the basis of some sort of futility, on the basis of the patient's best interest, or using some other legal test. And we need to also recognize that different jurisdictions might have different ways of thinking about futility. Artificial nutrition and hydration in cases involving patients in permanent vegetative states is widely accepted in the UK that treatment is futile in a legal sense, in that it can do nothing to bring the patient back to some sort of level of functioning. In Italy, there's recently been a very significant series of judgments in a case about a young woman called Eluana Inglaro, where there was really a big debate not only about whether or not it was ever possible to say that a vegetative state was permanent or even persistent, but also about how decisions should be made in these cases, even if we could say that there was such a thing as a permanent vegetative state. So you get a wide variation on those sorts of issues. So when is refusal of treatment effective? Well, it really does, again, depend on the jurisdiction. So jurisdictions which are common law-based tend to have a legal right to refuse treatment, even if that refusal will result in death. And there are a few civil law jurisdictions which also have such a right, so the Netherlands, Belgium, and Switzerland. But in other jurisdictions, this right is often quite limited. The French have repeatedly, in a number of different pieces of legislation, stated that there is a right to refuse treatment, but in practice, that right is often overridden, and indeed, in cases involving some litigation about that right, it's been held, for instance, that Jehovah's Witnesses can be transfused even when they have an advanced decision to refuse transfusion, or even when they contemporaneously refuse transfusion. So I've given that example there. In Italy, the refusal of ventilation by a competent patient who was tetraplegic was not effective. And then if we look at advanced decisions to refuse treatment, I've given some examples of legislation or positions in practice where these are taken into account by the doctor who's ultimately making the decision, but are not binding on him. There's a bill currently in Italy, which I think now is passed both the House and the Senate, but it's got to go back to the Senate, I believe. And if you look at that bill, not only does it exclude artificial nutrition and hydration from the sorts of things which you can refuse, but you can only refuse effectively if that treatment is considered by your doctor to be disproportionate, and any such refusal is inapplicable when your life is in danger, so your ability to refuse life-sustaining treatment is extremely limited. Denmark limits advance refusals only to cases where the person is terminally ill. So for instance, the kind of advance decision to refuse treatment which I have, which was specifically drafted for a situation where I was undergoing minor knee surgery, and I thought, well, if there's an anesthetic accident, I don't particularly want to be fed and hydrated in a permanent vegetative state, so I drafted this advanced decision. That sort of advanced decision would not be valid in Denmark, because even if I did end up in Denmark in a permanent vegetative state, I wouldn't be considered terminally ill. Similarly, there can be limits on the role of a proxy decision maker. So in France, you can appoint yourself a proxy decision maker, but all that gives the proxy is the right to be consulted about any decisions which are made in relation to your treatment. It doesn't give that person the right to make the decisions. Okay, what about symptom alleviation? Well, in addition to being the subject of really quite a lot of medical controversy, there's also a lot of legal controversy about this across Europe. Most jurisdictions have some kind of acceptance of symptom alleviation with the possible or probable hastening of death. And I'm going to come on in a moment to whether or not symptom alleviation does have the effect of possibly or probably hastening death in any circumstances. So what we're talking about here is usually the administration of opioids, often some form of morphine, which are administered for pain relief or some other form of symptom alleviation, and there is a question about whether or not that administration might possibly hasten death. Some jurisdictions deal with this by simply redefining the concept of intention in the criminal law. So although usually if you know that something will happen as a result of your actions, you're said to intend it. The doctrine of double effect is used to redefine intention to exclude that kind of what lawyers call oblique intention, so that the only intention that counts is when your purpose is to cause the person's death. And Switzerland is another example of that. Some jurisdictions deal with this in quite a different way. They use what's known as the medical exception. The medical exception exists pretty much across all jurisdictions. So if you think about an appendectomy, I was going to say appendicectomy, which I've been taught to say in the UK, an appendectomy, if I decide to perform an appendectomy on Constance, even if I do a really good job because all of my medic students have taught me how to do it, I am going to be guilty of a pretty serious assault because I am not a medical doctor. But if a medical doctor performs that procedure, even though it involves cutting into Constance's abdomen and causing some harm, hopefully less harm than the removal of the appendix is going to cause, that doctor will not be guilty of an assault. And that's because we have a sort of implicit medical exception in the criminal law for proper medical treatment or reasonable medical treatment, or however the courts formulate it. So in Denmark, the Netherlands, and France, it appears that this medical exception is also used for this kind of palliative symptom alleviation with possible or probable hastening of death, which makes some sense because we're talking about relatively normal medical behavior, but in most common law jurisdictions, anything to do with the end of life is generally falls outside of the medical exception and is dealt with separately. You couldn't, for instance, in any jurisdiction, make an argument that euthanasia fell within the medical exception and should be viewed as an exception to the law of murder in the same way as the appendectomy is viewed as an exception to the law of assault. Some jurisdictions deal with this by application of the defense of necessity. It's possible that this is what's going on in Belgium, but they don't have any litigation, so it's difficult to know. And sometimes what we end up with is some guidelines, often on terminal or palliative sedation, but with very little formal legal involvement. Now, the problem here is that in the past few years, there's been really quite some discussion in the medical literature about whether or not there really is a category that involves medically appropriate, medically indicated opioid or sedative use at the end of life, which has the effect of possibly or probably shortening life. And some of my colleagues have argued that there is no necessary association if you administer opioids appropriately and also sedatives, and that this kind of stretching of the criminal law to include, to accommodate this practice is actually not only no longer necessary, but possibly dangerous, because doctors know that there's something special about the way the law deals with these cases, and there's been an argument made that perhaps that results in a reluctance to use these sorts of medications which are needed in order to alleviate symptoms in a very vulnerable group of patients. Okay, assisted suicide. Well, like Canada, as I think probably most of you will know, given how much it's in the news these days, most European jurisdictions have a specific criminal offence of assisted suicide. England and Wales has one in the Suicide Act 1961, and Ireland and quite a lot of civil law jurisdictions, which I've listed there. Some jurisdictions have a more limited prohibition, so they only criminalize certain kinds of assisted suicide. And the example that people tend to know about here is Switzerland, although I think sometimes there's less focus on this in the media, so there's sometimes the impression that assisted suicide isn't a crime in Switzerland. But it is a crime in Switzerland, but only where the assister's motive is selfish. So the courts would have to assess what counts as a selfish motive, and there's some interesting jurisprudence. It includes not only financial gain, but also the gain that could result from publicity. So a doctor who made a television program about an assisted suicide was actually found guilty under this provision in the criminal code. Travel to Switzerland from more prohibitive jurisdictions is generally permitted. And that's what you see a lot of in the news. I know there's even been at least one Canadian case involving travel to Switzerland, and in the UK we have really quite a number of cases, and in Germany there are even more cases of people traveling to Switzerland for an assisted suicide. In Denmark they have two offenses. One is more serious if it's committed for reasons of personal interest. And I suppose you could make an argument here that England and Wales now has a kind of limited prohibition because we now have this policy, which I'm going to talk about more in a moment, which seems to mean that if you're not a doctor and you act compassionately to assist a suicide, you won't be prosecuted. There are some jurisdictions which don't have a prohibition. That doesn't necessarily mean that assisted suicide is lawful. In Scotland, they would argue that you could be prosecuted for other offenses. Similarly, in Germany, often in civil law jurisdictions, you might be prosecuted for failing to assist a person in danger, which is the sort of duty to rescue type offense, which is often used when comparing the criminal law systems of civil law and common law jurisdictions. So for instance, if you are driving along a French highway and you see a car accident, if you don't phone the emergency services, you have committed a criminal offense. And that's true in most civil law jurisdictions. You do have a duty to rescue. Or you might use the disciplinary law, and that tends to be used in Sweden. What about euthanasia? So remember, this is termination of life on request. Usually this is murder or some sort of variant of murder in most common law jurisdictions and some civil law jurisdictions. Sometimes there are provisions for sentence mitigation. So in England and Wales, you would be convicted of murder, but when you were sentenced, and you would be sentenced to a mandatory life term, that the amount of time the judge thinks you should remain in jail before you're possibly released on probation will be affected by whether or not there was a request for the termination of life from the victim. Or you could have your sentence aggravated by the victim's vulnerability, as in France. Quite a lot of civil law jurisdictions have a kind of lesser offense of consensual homicide, so that means if this is termination of life on request, it will be dealt with more sympathetically than if there's no request. In Spain, they've got really quite a narrow offense restricted to terminal illness or severe, unbearable, and permanent suffering. And then, of course, you're still convicted of a criminal offense, but it won't be as serious as if you were convicted of the straight murder offense. What about termination of life without request, which is, as some of you may know, a very hotly contested category empirically across Europe? Again, this will usually be, in terms of the legal position, it will usually be some version of murder. Again, if sentencing might be affected here by some presence of compassionate motive. Some of you will remember the Robert Latimer case in Saskatchewan a number of years ago, and so this might be the sort of case if it occurred in a jurisdiction where compassionate motive was recognized in sentencing, where he would have received a lesser sentence than the mandatory 10 years which he received here. Germany actually has a specific lesser offense of compassionate homicide, and so does Switzerland. All right, what about defenses? Well, if you're going to be convicted possibly of one of these really quite serious offenses, you might well be interested in what sort of defenses you might have. Now, those of you who know that euthanasia is lawful in the Netherlands and Belgium are thinking, well, if there's a criminal offense here, then how do you sort of have it be considered legal? And the way you do is you insert into the criminal code a fairly regulated defense for a certain class of defendants. And in the Netherlands and in Belgium, that class of defendants is doctors. In the Netherlands, this also applies to assisted suicide. In Belgium, it doesn't, but the commission that has been that is charged with investigating the reports of euthanasia has decided to also accept reports of assisted suicide. The defense of necessity. This is what happened in the Netherlands. What first happened in the Netherlands was doctors, and in some cases family members, terminated the life of their either patients or loved ones, and went to court and argued a number of defenses. And the one that sort of won out, the one that convinced the courts was, I had to act because I was in a situation of necessity. I had a conflict of duties between my duty to preserve life and my duty to prevent suffering. Courts have held that this conflict of duties only occurs for doctors. So that duty to prevent suffering is only strong enough to result in a conflict if you're a doctor and it's your job to prevent the suffering. So in those circumstances, what happened initially was the court said, okay, you have a defense, and now, as we saw in this earlier point up here, that defense has now been codified and then copied by the Belgians. So the Belgian law looks a lot like the Dutch law, but the Dutch law was preceded by 30 years of prosecutions, which resulted in the sort of accumulation of some legal criteria, which were then agreed by prosecutors and eventually codified, and then the Belgians basically cut and pasted that into a statute, modified a few things, removed assisted suicide, added some other bits about advanced decisions, and passed that as their euthanasia law. The necessity defense still remains in Belgium. Well, certainly in the Netherlands. It remains to be seen whether it remains in Belgium, but it certainly remains in the Netherlands, and it's used in all cases involving termination of life without request. So there are cases in the Netherlands involving the termination of life of severely ill neonates, and those are lawful according to court decisions involving the defense of necessity. Now, if you're not a doctor, you're more likely to use, you're more likely to use diminished responsibility. So it's often used for family members, usually inapplicable to doctors, and usually just knocks down the offense from a more serious to a less serious offense rather than exculpating completely. Okay, here's an example. This is the Dutch statutory defense. So this is what was inserted into the criminal code, which provides that if you meet these criteria, then you will not be guilty. You will have a full defense to the crime of termination of life on request. So if you look at what we're what we're sort of focusing on. We've got a request. We've got unbearable suffering with no prospect of improvement. You have to tell the patient about their prospects. You have to conclude that there's no reasonable alternative to euthanasia. Have to consult with another physician who has to agree on all of these points. And then you have to act with due medical care. If you use the wrong drug in the Netherlands, you will be found not to have acted with due medical care. If you use the wrong amount of the drug in the Netherlands, you will be found to have acted without due medical care. So the commissions to which you have to report that you complied with all of these rules, they look really quite closely at each of the criteria. Okay. Well, those of us who live in jurisdictions where we don't have a statute like the Netherlands, nonetheless, we don't have very many prosecutions. Now, we still need to look at the empirical data and find out, well, how much of this is going on. But from a legal perspective, one of the reasons we don't have very many prosecutions is because of the use of what we might call covert tools. So ways of not prosecuting or not ending up convicting people of these sorts of offenses. So either you decide not to prosecute, this is very common in France, you just decide not to prosecute, divert to a disciplinary process. You make decisions about what to charge people with. There was an interesting case a few years ago, which I think might have been in Nova Scotia, involving a doctor called Nancy Morrison. If you look at what she was charged with compared to what she might have been charged with, there was quite a selective charging decision. You can have a court quash the indictment or refuse to indict. You can accept guilty pleas to lesser offenses, even though it's quite clear that a more serious offense has been committed. We've already seen some manipulation of the concept of intention. There's quite a lot of examples of cases where the concept of causation is manipulated. There's an interesting Italian case called Forzati, where they disconnect a ventilator from someone who is clearly alive, but then find that, well, maybe they died before the ventilator was disconnected, so therefore the disconnection of the ventilator didn't cause the death. Jury nullification, very common in this context. So the jury decides, yes, you've met all the criteria, but we're not going to convict you anyway. And we've already seen light sentencing based on compassionate motive. And in some jurisdictions, you may also have the possibility of a pardon. Right, a little bit more in-depth look at England and Wales. So I'm going to focus on assisted dying just because that's what's been sort of in the news and sort of quite interesting in England and Wales recently. But I'm happy to talk more generally when we get to the discussion about how all of the other end-of-life decisions are made in England and Wales. So euthanasia is murder, consent and or request and or the offender's motive being compassionate. None of that makes any difference in terms of guilt or innocence. Mandatory life sentence if you get convicted of murder, but there is this tariff which the judge must set, and if the defendant believed he was acting mercifully, then that can affect the tariff. Diminished responsibility, often used very successfully by family members, knocks the offense down to manslaughter, which doesn't have the mandatory life sentence, and you can often get away with a non-custodial sentence. Not available to doctors generally, and has recently been reformed in England and Wales, now requires the diagnosis of a recognized medical condition in the offender, so the person who's committed the offense. Who's terminated the life of somebody, and that can sometimes be quite difficult. So it might mean that this defense is less available. The defense of necessity, often argued for in this context. Robert Latimer argued for this in the Canadian context. There have been attempts in the British context as well. There was an exception made to the general rule that it's unavailable as a defense to murder in the case of the conjoined twins in 2001. Where the operation was going to result in the death of one of the twins. But that exception was hedged about by the court, who were keen that it not serve as a precedent in cases of euthanasia. Okay, what about assistance with suicide? This is where all the media attention's been focused recently. This is the offense in the Suicide Act 1961, recently amended in 2009 to attempt to deal with teenagers in chat rooms online, encouraging other teenagers to commit suicide. So that was the reason for the change in wording. And there's this interesting provision, which is that you have to get consent for every single prosecution under this provision from the Director of Public Prosecutions. So there's a sort of another way of resulting in fewer prosecutions is every single prosecution has to go through the top, which is quite unusual. There was a prosecution about distribution of a booklet by members of the Voluntary Euthanasia Society, but there are very few prosecutions. This provision, as I've said, is rare, and it is a recognition that although someone might have committed the offense, fulfilled the elements of the offense, there may be cases where it's not in the public interest to prosecute it, and that's what the Director of Public Prosecutions is supposed to be deciding. Is it in the public interest to prosecute? And here we have an example of a case where the local authority, so this is sort of like the local area where you live, found out that a severely ill woman was planning to go with her husband to Switzerland to obtain assisted suicide, and the local authority got an injunction preventing the husband from doing this, and it went to court, and the High Court said, well, you know, we've had her examined, she's perfectly competent, she's making her own decision, there's nothing you can do to prevent her from going to Switzerland or to prevent the husband from assisting her. Which is interesting in and of itself because the assistance that was undertaken within England and Wales would certainly have been enough technically to fulfill the elements of the offence. I mean, booking an airline ticket is an act capable of assisting the suicide of another person if that airline ticket is to take you to a clinic in Switzerland where you're going to obtain assistance in suicide. We've had our own attempts to decriminalize assisted suicide by using constitutionally entrenched human rights. We don't have a charter in the UK, as some of you will know, but we do have the European Convention on Human Rights. This Diane Pretty case, very similar to the Sue Rodriguez case, even down to the same disease. These kind of slow-acting neurological diseases tend to be unduly prevalent in assisted suicide litigation. She wanted the DPP to promise not to prosecute her husband. DPP said, I'm not promising that. She then appealed that all the way to Strasbourg, which is where the European Court of Human Rights is, and she lost. Just like Sue Rodriguez lost, and the US cases, which went to the US Supreme Court, Glucksberg and Quill. So this seemed sort of a dead end, this kind of rights-based challenges to assisted suicide prohibitions. And indeed, we then had a bill introduced into the House of Lords, and the Select Committee on the bill pointed out that there were no published guidelines on when these cases would be prosecuted, and that the DPP indeed believed it would be inappropriate to issue such a policy. But then we had this case. I have to say, before this case started, or when it was just starting, I thought that there was no way this case would be successful based on the previous jurisprudence. But what this woman argued for, Debbie Purdy, is that she wanted basically an admission from the DPP that he wasn't going to prosecute anyone who took their relative to Switzerland, which appeared to be true because no one had ever been prosecuted for taking their relative to Switzerland. So instead of arguing, you're violating my constitutional rights by criminalizing assisted suicide, she picked a much smaller battle, which is, I think you have a policy that says you won't prosecute anyone who takes their relative to Switzerland, but you're not telling me that. And just like in the Canadian Charter, the European Convention on Human Rights has a requirement that any limits on a constitutional right be in accordance with the law. If I recollect my charter language, it's something about be prescribed by law. Right? So what Debbie Purdy is saying is, you've got a limit on this right. That's the my right to respect for my private and family life, equivalent to a sort of Section 7 argument over here. You've got a limit on this right, which is the offense. But maybe you don't really have such a strong limit because you're never prosecuting people who take their relatives to Switzerland. So I want you to tell me that so that I know exactly what the limit is on my right. And if you don't tell me that, then your limit is not in accordance with the law. And that is what the House of Lords accepted. They said it appears that there's a policy, but you're just not telling her that there's a policy. So you have to tell her what the policy is. So we have this timeline, which I put up here just to show you exactly how quickly this all happened. July 2009, the House of Lords decided this case and said, you must issue a policy. In August 2009, the DPP announced that he wouldn't restrict his policy to cases involving taking your relative to Switzerland. So it would be for all assisted suicides, which was a big step, a lot more than what the House of Lords asked for. He then published an interim policy a couple of weeks later. He had a public consultation for 10 weeks. He received almost 5,000 responses. A large portion of these, we think, were forms that were distributed through churches and other organizations where you ticked off what you thought about different aspects of the policy. And then 6 weeks before he had promised it, he then issued the final policy, which means that he took, basically including Christmas, he took about 6 or 7 weeks to finalize his policy. And this is the final policy. What I've sort of tried to summarize it for you. So you get what you would expect, which is you need a request from the victim. It's got to be competent, informed, and voluntary. And then there's some issue about what kind of condition the victim needs to be in or needs to have. And we'll come back to this point in a moment. In relation to the suspect, and this is the DPP's language, not mine, there is some question about whether you have to be an amateur, or could you be a professional, i.e. a medic or some other healthcare professional, and what the suspect's motives are. So there's a factor in the policy. The policy is a list of factors. Factors in favor of prosecution, factors against prosecution. There's a factor in the policy that you are less likely to be prosecuted if you were wholly motivated by compassion, and also if you were reluctant. Now, to avoid creation of a regulatory regime, and that's the DPP's language, he didn't want to be seen to be creating a regulatory regime, so he didn't require that the request be in writing, he didn't impose a residency requirement, none of the sorts of kind of nuts and bolts of such a regime, but just the sort of broad outlines. Now, I said we would come back to the victim's condition. So, in the first iteration of this policy, the victim had to, well, didn't have to, but you were likely to be prosecuted if the victim didn't fall into one of these three categories, and you were unlikely to be prosecuted if they did. So, terminally ill, severe and incurable physical disability, or severe degenerative physical condition. Now, somewhat unsurprisingly, the DPP was criticized on the basis of anti-discrimination law, both in terms of the European Convention on Human Rights, which does contain an equality provision, but also domestic anti-discrimination law, about the singling out of these categories. And so what he did, he just removed them. So he just took out this category, so now there's absolutely no restriction on the victim's condition. The victim doesn't have to be in a particular condition, doesn't have to be experiencing any kind of suffering, just nothing about that. So if you think about the other regimes that we've looked at very briefly, the Netherlands and Belgium, there is a restriction to someone who is suffering unbearably with no prospect of improvement. And there also has to be no reasonable alternative. So that really narrows down the category of people who are eligible under those regimes. But here, the rejection of a condition-based requirement without any kind of attempt to look at a suffering-based requirement means that this is the most liberal regime of any of the permissive regimes, if you consider this to be a regime. And it fails to, for instance, distinguish between someone who is terminally ill and experiencing unrelievable suffering, and we could argue about whether or not there is such a thing as unrelievable suffering, and someone who is, for example, suffering from depression. Well, you might say, surely the depressed person will be caught by this, because they have to be making a competent, informed, and voluntary request. But it turns out that when you look closely at the capacity of people even with severe depression, most of them have capacity. So I've put 2 sites in here of studies which looked at hospital patients diagnosed with depression Most of them will pass a standard capacity assessment. Okay, what about the suspect? Well, they've got to be motivated by compassion, but with no definition of that, despite criticism of this in the consultation. So what do we mean by compassion? What does the DPP mean by compassion? It can't really be a response to suffering because there's no requirement that there be any suffering, as we just saw. So this is unlike, as I said, the Dutch and Belgian regime. So perhaps it's more like the Swiss approach, which is you can't be acting selfishly. If you're acting selfishly, then it's a criminal offense in Switzerland. So perhaps this is compassion as an unselfish motive. And then we said that the suspect has to be reluctant. There's two factors here. One, you're less likely to be prosecuted if you sought to dissuade the victim, and you're less likely to be prosecuted if your actions may be characterized as reluctant encouragement or assistance in the face of a determined wish on the part of the victim to commit suicide. So imagine the following scenario. You've got a terminally ill partner, they're suffering, you have a discussion with them, or many discussions with them about what they want to do, and at the end of all of those discussions, you agree with them that assisted suicide is the right thing for them, and you agree to help them. Well, that makes you more likely to be prosecuted because you weren't reluctant and you didn't seek to dissuade your victim. Finally, amateur versus professional. There's this list of factors, I've singled out 5 of them, which makes it very unlikely that any healthcare professional is going to assist a suicide. And if they do, they're much more likely to be prosecuted, which they're well aware of because there's been lots of publicity about this. So the result is that what we're going to end up with is a kind of limited, what I've called amateur activity, where you get people assisting who don't know what kind of medications to use, they don't have access to the really good medications, and they have no assistance from professionals or even advice from professionals. People in this position are likely to continue to seek assistance in jurisdictions where they can get access to advice and the good medications. And so we're probably in a position where we're going to continue to export our assisted suicides to Zurich rather than dealing with them in the UK. And of course, not everyone can go to Zurich. So people have financial limitations, Dignitas is expensive, health limitations, social limitations make that difficult. All right, so how might we reform the law? Basically, we've never been successful with this. We could think about lesser homicide offenses. We could legalize completely based on either compassion or request. I've listed some examples, and you'll notice they're all prefaced with the word failed. That's because all of these bills have failed in whichever parliament they were in. And we could limit those routes to either specific groups of people, like doctors, for instance, as in the Netherlands and Belgium, or we could prohibit specific groups of people from acting. So some doctors in the UK who are opposed to assisted suicide would argue that doctors should never assist in a suicide. What do we know about observance of the law? We've got some data, but not very much good data. Some recent data from a colleague of mine called Clive Seal. So euthanasia, we've got no systematic data. There's a little bit of data from the 1980s. Assisted suicide, we know that there have only been a very few number of prosecutions. No prosecutions since the policy was issued, and the DPP gave an interview to the Times this month saying that he's considered personally over 30 cases since February 2010, and there have been no prosecutions. We also have very bad data on assisted suicide travel. There's just media reports. We think it's about 140 British suicides at Dignitas since 2002. And then the only systematic data is from 2001 to 2004, where we had 23 UK residents go to Dignitas. We know those numbers have increased quite a lot since then. No prosecutions. We've got that Rezed case that I mentioned earlier. But no prosecutions for assisted suicide travel. All right, I'm just going to look very, very briefly at some empirical evidence. So this is, I'll leave aside the caveats, but my empirical colleagues make me put these things in my math training. So these are all anonymous prevalence surveys of doctors. So we only have data for doctors. We don't have non-doctor data. This is abstention and symptom alleviation, which the doctor thinks either hastened death or resulted in death. Probably the more recent UK data is probably better because it was a bigger sample, but you'll notice that the older UK data is extraordinarily. Look down here, we're actually talking about really quite a large number of deaths. So this is the 50% line. 50% of all deaths in Switzerland involve either abstention or symptom alleviation. At least that's what the doctors think. So it's interesting how similar these numbers are across a very wide range of legal regimes, except for Italy. Right? Italy, they just do not do very much abstention. Now, these are the numbers that get everyone excited, but before you get excited about these numbers, I want you to look down here. So see this? This is a 4.5% line. The previous graph, we were up to almost 60% at that point on the graph. So the scale is radically different here. So here we have euthanasia, termination of life on request is the lime green. Termination of life without request is the purple, and this kind of bluey color is physician-assisted suicide, unsurprisingly in Switzerland, lots more. But the Netherlands, lots of euthanasia, unsurprising since it's lawful. Belgium, lots of euthanasia, unsurprising since it's lawful. Belgium, termination of life without request, an awful lot. Not lawful at any time period in Belgium, yet they're doing tons of it. Everyone else, termination of life without request, quite a bit in the Netherlands, like I said. It can be lawful, particularly for neonates. Switzerland, again, that's not lawful. UK, none of this is lawful. Very tiny numbers, though. Denmark, really quite a lot of termination of life without request for a prohibitive jurisdiction. But really, the sort of outlier here is Belgium. They were doing quite a lot of euthanasia before legalization. Both of these are before legalization. And they're always doing a lot of termination of life without request, both pre and post legalization. Okay. This is just one little comparison. This is my last empirical slide. End-of-life decisions compare the Netherlands and the UK. So this is about 40% of all deaths involve an end-of-life decision in both jurisdictions. Interestingly, the Dutch seem to be doing more symptom alleviation, less abstention. UK, we do a lot more abstention, less symptom alleviation, or maybe we just know that symptom alleviation doesn't hasten death in most cases. Now, certainly they have a bigger chunk that is assisted dying. Most of their assisted dying is euthanasia. We have a smaller chunk that is assisted dying, and most of our assisted dying, but this is a tiny, tiny number, is termination of life without request. But still, it's less than 1%. So it's a little bit misleading, but just remember how tiny this part is. These are my sources of data. And let's see. What can we conclude? Not very much, because we don't have an enormous amount of legal change or an enormous amount of data. But we could say that neither the legislature nor the judiciary have been willing to legalize assisted dying in England and Wales. But we've had this really quite extraordinary informal legal change, which was accelerated by what I thought was a surprising decision in Purdy, and then the DPP's decision to expand his policy to include all assisted suicides, not just travel to Switzerland. And this, I think, this policy really describes, granted in a sort of bizarre way, using these factors, a class of legally permissible suicides, assisted suicides. So if you're a family member, you're acting compassionately, you don't have a financial motive, or it's a, sort of relatively minor, I'm going to inherit a bit in the will type motive, or type, maybe not type motive, type factor, then you're very unlikely to be prosecuted. And like I've said, this policy includes cases which would not be permitted under any of the existing permissive regimes. So assisted suicides could occur lawfully in England and Wales, which would not be permitted in the Netherlands or in Belgium or in Switzerland. What about practice? Well, if you remember that graph, you'll see that generally in England and Wales there's very little assisted dying. And other medical behavior which potentially shortens life is preferred. Clive Seal has argued that this reflects a culture of medical decision-making informed by a palliative care philosophy. And I think all we can we can conclude about non-physicians is that we have no robust empirical evidence about the prevalence of assisted dying by non-physicians in the UK. Thank you very much.
Don't you go away. Thank you very much, Dr. Lewis, for that incredibly sweeping and yet extremely detailed presentation. We're now going to open the floor for questions.
Philip Welsh, I'm a physician. You mentioned jury nullification, but maybe you stated it and I didn't pick up on it exactly where that applied and exactly what the jury's position was. It seems to me that potentially in this situation, for many countries, not excluding Canada, that the jury might take the same view as they did in the celebrated Morgenthaler situation with abortion and simply say, okay, you're not guilty, never mind, go away and don't do it again, so to speak. And eventually, after I think 3 attempts or 3 tries of doing that, we wisely, according to some, decided, well, let's just leave it alone. From a legal point of view, there's enough damage going on without getting into this one, and nobody now wants to touch it. Could that apply to assisted suicide here or elsewhere?
I mean, Morgenthaler is the classic example of jury nullification in Canada. You're absolutely right. That is what is cited as the sort of paradigm of jury nullification. There's very little evidence about it, so you get these sort of anecdotal kind of claims that a particular case involved jury nullification, and you certainly get defense lawyers talking about how they were aiming for jury nullification. So they will tailor their arguments to trying to convince the jury that even though their client is guilty, they shouldn't convict him or her. My personal view is that we almost tend to get a kind of prosecutorial response that expects jury nullification and therefore doesn't prosecute or make some kind of deal. So that what you tend to see is an unwillingness to go the full sort of, we're going to prosecute you for some form of assisted dying. So there's a doctor in the UK called Michael Irwin who has not only said that he's been involved in assisted deaths, but he also paid for somebody to go to Dignitas and did that publicly. He's invited the DPP to prosecute him. And this is exactly the sort of behavior, well, maybe not exactly, but this similar behavior to what happened in the abortion context in the UK, which is that a doctor called Alec Bourne performed a termination of pregnancy on a young rape victim, and he sent a letter to the police saying, please prosecute me because I want to challenge this law. And so he was different from Morgenthaler, but it was a sort of similar type challenge. And the DPPs just refused to prosecute Irwin for assisting a suicide. So it's almost like you never get to jury nullification anymore because the prosecutors are well aware of what might happen. And so either they just don't prosecute, or they maybe make a deal for a lesser offense or agree that there'll be some sort of disciplinary sanction but no criminal sanction. So it's almost like the threat of jury nullification is enough, that you don't actually need very much jury nullification.
This may not be a totally fair ancillary question, but do you know whether the celebrated omnibus bill, which we are shortly going to enjoy, is that going to change the situation with regard to this area of prosecution and sentencing?
I don't know. I have heard that there's an omnibus criminal justice bill, but I certainly haven't heard that it has any impact on assisted dying, but I am not as up to date with Canadian criminal justice matters as I might be. So I'd be quite happy if someone else wanted to jump in there.
I'm sure it will, but I said it wasn't a fair question.
Hello, this is a clarification question regarding the Dutch statutory defense.
Okay.
In terms of the unbearable suffering, how has that been interpreted? Is it limited to physical suffering, or does it include psycho-existential suffering?
Okay, so that's a very good question. It does include suffering which stems from a psychiatric condition. So there is a very famous case called Chabot, depending on how you pronounce it, involving a patient suffering from a clinically diagnosed depression. Many treatments have been tried. The doctor decided to go ahead and assist her suicide after many, many requests and consultations, etc. And he was prosecuted, and this case became the authority for the proposition that suffering which has a non-somatic cause, including suffering caused by a psychiatric illness, could count as unbearable suffering under what was then a sort of series of judicial decisions and prosecutorial guidance. So it predates the statute, but nothing has changed. There was also a case slightly more recently called Brongersma, involving a senator who, very elderly, had been a senator, and was said to be suffering existentially, or what the Dutch often called was tired of life. And his GP agreed to assist his suicide and did, and he was then prosecuted. And the court found that there was no medical consensus that that sort of suffering should count as unbearable suffering for the purposes of the euthanasia, well, what is now the euthanasia law. So there seems to be a distinction between suffering which is related to a recognized medical condition or psychiatric condition and suffering which isn't. There's certainly an enormous debate in the Netherlands at the moment, but dating from the 1980s, about this question of whether people who are simply elderly and, quote, tired of life should qualify, whether they should maybe be dealt with in a different way than the sort of medical model in the Netherlands. Like, people talk about once you hit 70, you should have access to a pill. There was a Dutch politician who sort of got this pill named after himself called Drion, so people talk about the Drion pill. And now there's this movement in the Netherlands which has been quite active in the last few months. They launched a new campaign called Uit Vrije Wil, which is sort of from free will. So an argument about a Dutch phrase, voltooid leven, which means completed life. So that at a certain point you make a decision that your life is complete and you'd like to end it. And you would then have access, possibly through non-medical assistance to do so. All of this is a big topic of conversation. If you talk to people who are actually involved in the law in the Netherlands, people generally do not think it's likely that the law will be changed to include that sort of suffering. But it is certainly, if you went there, there would be lots of people talking about it.
I'm interested to know whether there's any discussion about mental health issues on the part of the facilitator of assisted suicide. For example, if I'm the partner of someone who has been dying in unbearable suffering, and I might be considered to have a temporary psychosis or a post-traumatic stress disorder, and be wholly moved by compassion, but perhaps, you know, under the circumstances not be making what would be considered a usual decision. Would that be my diminished responsibility?
Yes, it would be. That's exactly what it would be. So those cases, and those cases do exist. Those cases lightly fall if what you do is actually terminate the life of your loved one. In those circumstances, they lightly fall under diminished responsibility, even under the new formulation of it. There's an interesting problem, which is diminished responsibility is only a defense to murder, and what it does is it reduces your culpability from murder to manslaughter. But it's not a defense to assisting a suicide. Of course, now you're not very likely to be prosecuted for assisting a suicide for other reasons not related to your diminished responsibility, but because you're acting compassionately. You know, maybe you've been pressured by your loved one, which in a lot of these diminished responsibility cases, there involves quite a lot of pressure. It's usually a spouse who's really been pressured to assist. What I think there's really not been is any consideration of the impact of this new policy on people who are then going to come under tremendous pressure, whether it's pressure that they themselves create or whether it's pressure created by their loved one, to assist, because now you've got a situation where the only people who can really assist lawfully are people who are family members or friends who aren't professional who aren't healthcare professionals, or who have some sort of pre-existing relationship with the victim, and you know, that's a tremendous responsibility. Constance and I were talking last night about the difference in the UK, that most end-of-life decisions are made by doctors. So there are very few. We've only very recently introduced a system of proxies, and almost no one has one. It's very complicated to appoint one, and it's expensive. So most end-of-life decisions are made by doctors. And when you talk to doctors, when they're exposed to a system where most end-of-life decisions are made by proxies, they say, well, that's very unfair on the family member. It's a lot of responsibility, and then you feel responsible for your loved one's death, and they think that that's some kind of abdication of responsibility by the healthcare professional. Well, if we think about this situation, in a way it's even worse, because now you really are legally responsible for your loved one's death. It's just that the DPP has decided it's not in the public interest to prosecute you.
Is there any kind of follow-up study that's ever done for the people who act as proxy, or... Because I'm not aware of any. This
is very new in England and Wales, so I think the answer to that is no. There are some studies in the Netherlands about doctors who participate in euthanasia and assisted suicide. And there's some evidence of burnout. So you do get some doctors who say, I used to do it, but I won't anymore because it's just became too difficult. And doctors do talk, in qualitative research, they talk about how burdensome they find it. And how sometimes they feel that patients think that it's easy for them, and it's not, that it's not easy for them, and that they find it really quite a difficult thing to have to do, but that they often feel like that they must do it. If you look at Dutch healthcare practice, they have much longer relationships with their general practitioners than is the average across Europe, certainly compared to the UK. And most acts of euthanasia are carried out by the patient's GP. Often they've known them for 20, 30, 40 years. So you can see that they might feel that they have to do it, but they still find it quite burdensome.
Thanks very much.
Just a quick question on the question of competency. Is that usually defined in the same way as, say, medical condition would be by consensus?
It's interesting, because one of the big problems with the DPP's policy was that he kind of just used some random definition of competence and didn't pay any attention to the definition of competence, which is in the statute, which regulates decision-making for those who don't have capacity, which is called the Mental Capacity Act. So I think a number of people, myself included, pointed out that perhaps he should align his definitions of competence with the one that's in the Mental Capacity Act. And so he did. And so the definition is now basically what's in the Mental Capacity Act, which you can look at. But it's basically a two-part test. The first part is you have to have some sort of condition which is impairing your ability to meet the sort of cognitive criteria in the second part. So, you know, it can be a medical condition like a brain tumor, or it can be intoxication, for instance. So a condition that is impairing your ability to either to do one of the three things that you have to be able to do, which is understand the information presented. Actually, there are four things. Understand the information presented. Retain it, weigh it in the balance to reach a decision, and communicate your decision. And the last one is in there to deal with people who are locked in. So you could be perfectly competent cognitively, but if you can't communicate your decision, we have to have some way of making decisions on your behalf. So, so basically the test for capacity for assisted suicide is now in line with that. So of course there will be people whose condition prevents them from being competent towards the end of their life. And so they would fail that test, both in terms of treatment and in terms of assisted suicide.